The first half of 2025 was yet another reminder that we live in a time of great geopolitical uncertainty and a new age of EU sanctions. As leaders headed into the June 2025 G7 summit, an opportunity arose to find renewed convergence around coordinated sanctions on Russia. Unfortunately, the outcome fell short of expectations. But the EU stayed the course, continuing to work on more Russia sanctions, for a third time this year on the assumption that they might be imposed without new US engagement. As the month of June 2025 draws to a close, and with it the Polish presidency of the Council of the European Union, this episode provides a mid-year review of some of the key developments in the EU sanction space. First, Russia. What is the status of EU sanctions against Russia precisely? Can the EU maintain and raise the sanctions pressure, beginning with an 18th package, as Russia intensifies its attacks on Ukraine? Second, Syria. What were the mechanics leading up to the lifting of EU sanctions? What are some of the policy and perhaps most importantly practical takeaways from this important decision? After these two questions, I will turn to a focus issue at the crossroads of sanctions compliance and dispute resolution. Looking at a case pending before the Court of Justice of the European Union, I will try to set the stage for a discussion that will likely intensify in the coming months, and that will ask to what extent EU sanctions and international arbitration might be on a collision course. I am Jan Dunin-Vazovic, partner at Benning Dunin-Vazovic, a European law firm based in Paris and Amsterdam, focused on sanctions, export controls, and trade compliance more generally. You are listening to This Month in EU Sanctions. Thank you for joining the program. To understand the state of play regarding the proposed 18th package of EU sanctions against Russia, it is helpful to take a step back and map out the relevant developments since the beginning of the year. A distinctive feature of EU sanctions in general is that they need to be periodically renewed or extended to remain in force. Like for the adoption of new measures, each decision to renew sanctions requires a unanimous decision of the Council. And so, in the Russia sanctions context, beyond the discussions on potential new measures, the Council regularly needs to ensure that the extensions are voted for each legal framework used as part of the Russia sanctions policy. On January 27, 2025, the Council renewed the EU sanctions in view of the Russian Federation's continuing actions destabilizing the situation in Ukraine for a further 6 months until July 31, 2025. The decision noted that as long as the Russian Federation continues to violate fundamental rules of international law, it is appropriate to maintain in force all the measures imposed by the EU and to take additional measures if necessary. A few weeks later, as Russia's war of aggression against Ukraine entered into a fourth year, on February 24, 2025, the EU adopted a comprehensive 16th round of sanctions against Russia. The 16th package was significant in many respects. By then, the new Trump administration was sworn in. The EU confirmed the course of its sanctions policy vis-à-vis Russia at a pivotal moment, that is, without coordinated actions with the US. Again, highlighting its own security interest, the Council of the European Union noted in relation to the suspension of certain broadcasting activities that those measures should be maintained until the war of aggression against Ukraine is put to an end and until Russia and those media outlets cease to conduct propaganda actions against the EU and its member states. Speaking in Kyiv on February 24, 2025, European Commission President von der Leyen stated that the EU will increase punitive sanctions against Russia unless they demonstrate true willingness to achieve a lasting peace commitment. On substance, with the 16th package, the EU adopted a significant round of measures comprising individual actions, sectoral measures, compliance enhancements, while increasing the global reach of EU sanctions through new tools. It targeted additional sectors of the Russian economy, continuing to crack down on circumvention through various measures. Interestingly, a new listing criteria was added concerning persons forming part of, supporting, materially or financially, or benefiting from Russia's military and industrial complex. Export controls targeting dual-use items, as well as advanced technology and goods contributing to the enhancement of Russian industrial capacities, were also strengthened. The EU continued to respond to Russia's shadow fleet activity through the listing of non-Russian fleets, as well as to allowing the listing of financial service providers that are facilitating transactions on behalf of said shadow fleets, and adding a new listing criteria in the asset-free sanctions program for persons owning, controlling, managing, operating, or providing services to these vessels. Compliance requirements and expectations were heightened through, among other things, the extension of the best efforts requirement to the asset freeze regulation, and the extension of the obligation to implement a risk-based compliance program to more goods. On March 6, 2025, the European Council adopted conclusions, firmly supported by 26 heads of state or government, in which it noted that the EU remains committed to stepping up pressure on Russia, including through further sanctions and by strengthening the enforcement of existing measures, in order to weaken Russia's ability to continue waging its war of aggression. On March 14, 2025, the Council extended the measures targeting those responsible for undermining or threatening the territorial integrity, sovereignty, and independence of Ukraine for another 6 months, until September 15, 2025. The March 20, 2025 European Council conclusions noted again, firmly supported by 26 heads of state or government, that the EU remains ready to step up pressure on Russia, including through further sanctions, and again by strengthening the enforcement of existing measures. It also noted, subject to EU law, that Russia's assets should remain immobilized until Russia ceases its war of aggression against Ukraine and compensates it for the damage caused by the war. On May 20, 2025, following Russia's refusal to agree to a comprehensive ceasefire in Ukraine, the Council adopted a 17th package of sanctions. The measures were adopted as part of an even broader set of EU sanctions targeting Russia. Alongside the traditional 2014 legal frameworks used to sanction Russia, the Council made use of the full range of tools available to it. For instance, it adopted restrictive measures based on regimes concerning Russia's destabilizing activities, domestic violations of human rights, and the use of chemical weapons. One of the key points of the 17th package is that the EU added 189 additional vessels subject to a port access ban and a ban on provision of services, bringing the total number of listings to 342. In this respect, the 17th package of sanctions represented the largest single action targeting the shadow fleet. Less than a month after adopting the 17th package, on June 10th, the European Commission presented a proposal for an 18th package of EU sanctions against Russia. The proposal includes a transaction ban for Nord Stream 1 and 2, the reduction of the oil price cap from $60 to $45 per barrel, the listing of an additional 77 vessels that are part of the Russian shadow fleet, a ban on the import of refined products based on Russian crude oil, the transformation of the existing prohibition to use the SWIFT system into a full transaction ban, the extension of this new transaction ban to another 22 Russian banks, the extension of the new transaction ban to financial operators in third countries that finance trade to Russia in circumvention of sanctions, the listing of the Russian Direct Investment Fund, its subsidiaries and its investment projects, the export bans worth more than 2.5 billion euros, as well as additional controls on technologies that are used for producing drones, missiles, and other weapon systems, the extension of the scope of the transaction bans that already exist, the listing of 22 Russian and foreign companies providing direct or indirect support to Russia's military and industrial complex. A week later, having proposed the 18th package of sanctions, the European Commission proposed a regulation on phasing out of Russian gas imports and improving monitoring of potential energy dependencies. The proposal aims to gradually and effectively stop the import of Russian gas and oil by the end of 2027. Work on the 18th package advanced with some hopes that these measures could be coordinated with the US. The possibility for renewed coordination on new sanctions has not so far been completely ruled out, with the US suggesting that all options remain open. However, G7 leaders' joint statements following the June 17, 2025 summit did not announce new coordinated sanctions. An effort was made to adopt the 18th package before the last meeting of the European Council before the summer break. That effort nonetheless encountered reservations by Hungary and Slovakia, reportedly arising out of the Commission's proposal for regulation to phase out of import of Russian gas. On June 30th, 2025, the Council renewed sectoral sanctions in view of the Russian Federation's continuing actions destabilizing the situation in Ukraine for a further 6 months until January 31st, 2026. Denmark will take over the presidency of the Council on July 1st through the end of the year. The first assignment of the Danish presidency might be to drive the 18th package across the finish line. Relatedly, the Russia sanctions bill is still under consideration in the US Senate. There is thus, in theory, still a possibility for the US and the rest of the G7 coalition to find convergence to increase the pressure on Russia in the coming weeks. The next meeting of the Foreign Affairs Council will be on July 15th. Another significant development occurred in the first half of 2025, the near-complete lift of EU sanctions against Syria. Following the fall of Assad's regime in Syria, the European Council had stressed on 19 December 2024 the historic opportunity to reunite and rebuild the country, underlying the importance of an inclusive and Syrian-led political process that meets the legitimate expectations of the Syrian people in line with the core principles of UN Security Council Resolution 2254. The December 2024 European Council conclusions largely mirrored a G7 statement on Syria from 12 December 2024. In this context, the European Council invited the Commission and the High Representative to submit to the Council options for measures to support Syria. The process that would follow involved 3 main steps. First, on January 27, 2025, the Council agreed on a policy roadmap to ease sanctions on Syria. While the EU aimed to move quickly following the transition, it indicated that it remained ready to reverse the course if the situation in the country were to worsen. The roadmap outlined a step-for-step approach, beginning with the sanctions that are most hindering the early build-up of the country, and to move from there. As previewed in this political agreement, the second step occurred on February 24, 2025, when the Council suspended a number of sanctions in view of the situation in Syria. This decision was part of the EU's efforts to support an inclusive political transition in Syria and its swift economic recovery, reconstruction, and stabilization. As the Council noted, the EU aimed to facilitate engagement with Syria, its people, and businesses in key areas of energy and transport, as well as to facilitate financial and banking transactions associated with such sectors and those needed for humanitarian and reconstruction purposes. As a result, the Council suspended certain sectoral sanctions, partially lifted some asset freeze measures, and amended certain exemptions and derogations to reflect and support the change of policy. On May 20th, 2025, following a May 20th political announcement, the Council adopted the third step, introducing legal acts to lift almost all economic sanctions on Syria, with those remaining being based on security grounds. At the same time, it introduced new sanctions against several individuals and entities under its EU Global Human Rights Sanctions regime, targeting 3 armed militias and their leader. These changes, as noted, came after the Council previously introduced partial sanctions relief on key sectors of the Syrian economy in February. The Council's sweeping changes to the EU-Syria sanctions regime provided significant financial sanctions relief, including lifting asset freeze measures targeting the Syrian Central Bank, along with entities operating in the financial, petrochemical, cotton, and telecommunication sectors, among others. Key trade sanctions were also lifted, including on sectors such as financial services, energy, aviation, and luxury. At the same time, the sanctions relief for Syria was not absolute. Targeted financial sanctions remained, imposed on individuals and companies related to the Assad regime, comprising over 300 listings. New listings were imposed under the EU Global Human Rights Sanctions regime, and trade restrictions on equipment, technology, and software that could contribute to internal repression remain. The EU thus keeps its ability to introduce further targeted measures, such as under the EU Global Human Rights Sanctions regime, depending on the evolution of the situation in the country, which it did in June 2025. Concerning exports to Syria, the EU sanctions relief for Syria did not affect the separate EU dual-use export controls legal regime. Member states may heighten their scrutiny of dual-use exports to that country moving forward. The developments regarding Syria show a few things. EU sanctions are reversible. They're not meant to be permanent and are inherently linked to policy interests. The decision to lift sanctions can come relatively quickly, but the lifting of sanctions follows its own logic, which can be sequenced and remain contingent on certain conditions. The easing of certain sanctions can trigger the imposition of other sanctions at the same time or impact other areas of trade compliance. Where other jurisdictions are involved in targeting a specific country or conduct, the lifting or easing of such sanctions, for it to be effective, requires a certain degree of coordination and alignment. Here, the lifting of EU sanctions, with some nuances between the legal regimes, was coordinated with the US, the UK, and Canada. All in all, re-engaging in a jurisdiction consecutive to a decision to lift or ease sanctions also requires appropriate risk-based due diligence and careful compliance planning. With over 40 sanctions programs in place throughout the first half of 2025, the EU took various measures under other sanctions regimes, such as Belarus, Iran, Myanmar, Libya, or Venezuela, among others. References to these developments are available in the newsletters. Meanwhile, effective implementation and compliance continued to be a key priority. Since the beginning of the year, several European Commission FAQs and guidance from member states were released. On March 25, 2025, the European Commission launched the EU Sanctions Help Desk, a platform designed to assist small and medium enterprises with compliance support. The EU Sanctions Help Desk offers personalized support to EU SMEs performing sanctions due diligence. Enforcement activity was reported across several member states and is likely to continue. In this respect, member states had until May 20, 2025 to transpose a landmark directive of the European Parliament and of the Council of 24 April 2024 on the definition of criminal offences and penalties for the violation of EU sanctions. Let's now turn to this episode's focus issue. EU courts, the General Court, and the Court of Justice play a central role in the EU legal sanctions framework. While their contribution to EU sanctions compliance is often underappreciated, it is important to remember that only the Court of Justice of the European Union is competent to interpret EU law. Historically, except for interpreting some provisions of the 2014 sanctions and a seminal case on the definition of circumvention, EU courts have to date had little opportunity to provide guidance on interpretation of EU sanctions. Since 2022, the spectrum of sanctions-related questions that have reached EU courts has nevertheless significantly grown, with the court's docket today made of both actions for annulment in the delisting cases or requests from national courts for interpretative guidance, which are called references for preliminary rulings. These new cases on interpretation come at a time where extensive, dense, extremely influential guidance from the Commission are provided in an effort to achieve the uniform application of sanctions across the EU. In addition, several member states have provided guidance on some key provisions of the regulations. So when the Court of Justice enters the debate on interpretative questions, everybody in the EU sanctions community is watching. Article 11 of Council Regulation 833/2014, also called the No Claims Clause, provides in general terms that no claims in connection with any contract or transaction, the performance of which has been affected, directly or indirectly, in whole or in part, by the measures imposed under EU sanctions, shall be satisfied if brought by a number of claimants, including any Russian person, entity, or body. While the fact pattern of case C802-24 is relatively straightforward, the legal questions that it raises are extremely complex. Let's take a look at the facts of this case as they are presented in a working document of the Court of Justice. On December 8, 2015, a Belgian company and a Russian company concluded a contract under which the former would sell and supply goods and provide certain services to the latter. The contract contained an arbitration clause under which all disputes, other than those falling within the jurisdiction of national courts, would be subject to international arbitration proceedings. Under the contract, EU sanctions against Russia would not be considered as force majeure, and EU sanctions would as a result not release the parties from their obligations under the agreement. Having concluded the contract, the Russian company made an advance payment for part of the contract price. In the spring of 2017, a Belgian authority decided not to issue a license for the export of the goods in question. The decision was adopted with reference to Regulation 833/2014, the Russia Sanctions, but also the dual-use regulation and the common position defining the rules governing control of exports of military technology and equipment. The Belgian authority considered that the stated goods were intended for the production of helicopter parts. An appeal against that decision was filed with the Belgian Council of State, which dismissed the application in September 2017, noting that it could not be confirmed that the goods were not intended for the production of military equipment parts. Since it did not obtain an export license, the Belgian company did not supply the goods, and the Belgian company did not repay the advanced payment. The Russian company then terminated the agreement and filed a request for arbitration. The arbitration was seated in Stockholm, Sweden. In the arbitration proceedings, the claimant, the Russian company, argued that the respondent, the Belgian company, should be ordered to repay the advance payment plus interest. In addition, it claimed that the respondent should be ordered to pay damages for breach of contract and other damages plus interest. Finally, it claimed reimbursement of its legal costs. The arbitral tribunal granted the claim for repayment of the advance payment plus interest and dismissed the other claims. According to the arbitral tribunal, the agreement between the parties was valid at the time it was concluded, including in the context of Regulation 833/2014. For the tribunal, the validity of the agreement was not affected by the refusal on the part of Belgian authorities to grant an export license. Nor did the arbitral tribunal find that there was anything to indicate that the agreement had been concluded with the aim of circumventing EU law. However, the arbitral tribunal did find that the respondent was prevented from fulfilling its contractual obligation, that is to say, supplying the goods, as a result of the refusal to grant the export license. In short, for the arbitral tribunal, the request for repayment of the advanced payment plus interest did not constitute a claim which is prohibited from being satisfied under Article 11 of Regulation 833/2014. According to the tribunal, the No Claims Clause does not cover a claim for repayment of an amount paid for goods which were never supplied. In the tribunal's view, such an amount and the related claim for interest do not indicate the performance of a prohibited transaction, but only aim to restore the parties to the position in which they were before the agreement was concluded. The tribunal noted that the right to repayment derives from the right of restitution under the United Nations Convention on Contracts for the International Sale of Goods. For the tribunal, not granting the Russian company's right to repayment and interest would constitute a disproportionate application of the No Claims Clause. However, the arbitral tribunal held that the other claims were covered by Article 11 as they constituted an attempt on the part of the Russian company to obtain a financial advantage resulting from the Belgian company's failure to perform a prohibited transaction. As a result, these additional claims were dismissed. Having lost before the arbitral tribunal, the Belgian company then brought an action before the local court, the Svea Court of Appeal in Stockholm, claiming that it should set aside the arbitral award. In essence, the Belgian company argued that the arbitration award violated public policy. The Svea Court of Appeal decided that the arbitral award may not be enforced until further notice. It stayed the execution of this award. In the course of the proceedings, the Court of Appeal found reason to consider whether the issues examined by the arbitral tribunal were arbitrable under Swedish arbitration law. The Swedish court also questioned whether the EU-Russia sanctions constitutes part of the European Union's legal order and whether the arbitral tribunal's interpretation of Article 11 was correct. In this context, the Court of Appeal decided to refer 3 questions to the Court of Justice. First, must Regulation 833/2014 be interpreted as meaning that parties to an agreement are precluded from reaching an agreement out of court on claims which, under the No Claims Clause, are not to be satisfied, and that amicable settlements reached by parties to an agreement on claims covered by Article 11 are null and void in civil law. Second, must Article 11 be interpreted as meaning that a national court hearing an application for setting aside or annulment of an arbitral award in which the No Claims Clause has been applied must determine on its own motion whether the arbitral tribunal's application of the law is compatible with EU sanctions, and, in such a case, must the national court annul or set aside the arbitral award in whole or in part if the arbitration tribunal's application of the law was contrary to EU sanctions. Finally, must Article 11 of Regulation 833/2014 be interpreted as not precluding satisfaction of a claim if the claim concerns a. repayment of an advance payment in respect of goods which were never supplied on account of measures under EU sanctions, b. interest on a claim mentioned in A. One of the complexities of the case is that several versions of Regulation 833/2014 are at issue. When the parties concluded their agreement, the regulation in force at the time was the version as amended by Council Regulation of 7 October 2015. When the Belgian authority and the Council of State refused the export license, the regulation in force at the time was the version as amended of 30th November 2017. When the arbitration tribunal rendered its award, the regulation in force at the time was the version as amended as of July 5th, 2019. And at the time the Court of Appeal is making the request for a preliminary ruling, the regulation in force is the version as amended of September 10th, 2024. In addition, the European Commission issued several answers to questions about the No Claims Clause under Regulations 833/2014 and Regulation 269/2014. The question presented is now, to what extent do EU sanctions limit the possibilities of parties for settling in private arbitration proceedings disputes such as the one in this case? Developments are expected in the coming months. The request was submitted on November 20th, 2024, and references for preliminary rulings are generally addressed in 18 months. This concludes this month's episode. If you've enjoyed the show, I hope you'll consider subscribing or writing a review on any platform you are used to. This Month in EU Sanctions is also a newsletter on LinkedIn. Links are available in the show's notes. Thank you for listening, and tune in soon for the next episode.